And what we have to say, and so thank you for coming. Today we have Professor Josh Blackman from the University of South Texas College of Law in Houston. He's very well known on the Federalist Society speaking circuit, and you all know Professor Maria Medina, and then Ms. Bryn Madway. She is from the Foundation of Individual Rights and Education, and prior to that, she went to George Washington University School of Law, and she was president of Lambda while she was there. And so we're really excited to see what they have to say about this topic. And once again, thank you all for being here, and I hope you enjoy the food.
Thank you. I will come up there to talk. And if you're still in the hallway, I will project my voice. Thank you very much. It's a pleasure to be here. The Loyola Law Review published my first law journal articles. I was still actually a clerk. And you guys published my articles back in 2010, so I am grateful for that. Thank you very much. Any law review people here? Well, thank you very much for that. The conflict is all too familiar. A controversial speaker is invited to speak at a university. The overwhelming majority of students don't care one way or the other. A small number of students want to hear what the speaker has to say, mostly because they agree with him, or maybe not, we don't know. And another small group of speakers don't want to hear what he has to say, and they often disagree with his message, and they might even object to his mere presence on the campus. Now, some of these students may protest outside the event, and some of the students may protest inside the event. They can be quiet protests, maybe standing in the back, taking a knee, whatever it happens to be. Or they may have vocal protests, shouting, screaming, maybe waving signs in front of the speaker. These approaches are what's commonly known as trying to deplatform. That's a word now, deplatform. In other words, remove the platform which he can speak. The speaker may respond in a couple different ways. He may respond with aggression, yelling back at the students. Or he may try to engage the students, ask them questions, try and get them talking. Or the speaker may abandon the event altogether. Maybe he did it voluntarily because he couldn't get his message across, people were shouting too much. Or maybe the school security officers removed him and they said that it's a threat for you to stay in this room to your personal safety. Invariably, when this happens, the speaker wasn't able to give the speech he wanted to give. The students weren't able to hear the speech they wanted to hear. And the protesters feel vindicated that their approach worked. All sides are basically unhappy when these things happen. The reason why this conflict I describe as familiar is because it happened to me. You are all here voluntarily. None of you are protesting me. None of you are shouting at me. Thank you. This isn't always the case. Last year, the Federal Society at CUNY in New York, the City University of New York, invited me to give a speech on free speech on campus. It's a topic I've spoken about many times before. Same way I'm talking to you. A couple days before the event, the president of the chapter, just like any of you guys, sent me an email saying that the students are organizing a protest against you. I think, wait a minute, a protest? What did I do to warrant a protest? I actually didn't believe him. I didn't think it was actually going to happen. But when I showed up on the campus, there were several dozen students in the hallway outside the room I was supposed to speak in. And the campus security officer came over and talked to me. And he said, "We need to talk about your security." I was like, uh-oh. And he asked me, "What is your exit strategy? What is your exit plan?" I was like, what? He's asking me, "How do you plan to leave the building?" I said, "Uber." He's like, "Okay, good, you're not taking the subway." Oh. Then it hit me. They were actually concerned about my safety and how I was going to actually exit the building if some violence happened. Again, I wasn't really sure. I am escorted into the classroom, and there are about 40 or 50 students in the hallway screaming at me, shouting at me, shame, calling me every name in the book. I didn't mind that. That was their right. I had no problem with people protesting outside the hallway. I think that's actually perfectly fine. It's kind of annoying, but whatever. I walked through it. And then when I got into the room, I tried to give my speech, same way I'm talking to all of you. And for the first 8 minutes or so, they were shouting at me and screaming at me and wouldn't let me get a word out. Eventually, I sensed they were getting a little bit tired, so I started engaging them and asking them questions, trying to draw them out. And they very quickly realized that they weren't going to scare me away and intimidate me, so they gave up, and they sort of went down the hall and went to the dean's office. But what happened to me is not common. It doesn't happen a lot. But it's happening increasingly often, where speakers, not always in the right, but generally in the right of center, are being protested on campus, and students are trying to deprive them of the right to speak. Now, I'm not here to tell you those students were all in the wrong. I am actually conflicted about this event because I try to look at it from my perspective as a law professor at the one hand, and on the other hand, man, they were really mean to me, right? But we're lawyers, we have to separate those two things. We can't entangle them. So what I want to talk about today is how to analyze these protests from different perspectives. From the right of the students who invite me, from the right of the students who want to hear me speak, from the right of the students who don't want to hear me speak. They got rights too. And my rights. I was invited to a public university to speak on a topic. And then finally, what is the obligation of the university, right, of the college? Not only to allow student groups to invite these sorts of speakers, but also what is your obligation when protesters show up? Do you impose discipline on the students? Do you arrest them if they won't leave the room? Do you then remove the speaker if it's a threat to his or her public safety? And if so, does that reward the so-called heckler's veto, where the protesters get to shut down protected speech? These are all very, very difficult questions, and I hope we have a good discussion about them today. So let's start talking about a different element, right? Who gets to spam? Who gets to invite speakers, right? Who gets to actually make invitations for speakers? Generally, in most colleges, it's a student group. And that's a good thing, right? You're all students, you have different interests, you have wonderful faculty here, but sometimes you want to hear different perspectives, something you haven't heard before. So I think it's a good idea that students can invite their own professors, or their own outside speakers. But can the university have an approval? It's sometimes problematic when the university says you can invite this speaker, not that speaker, because then it limits who students can hear. But there are often reasons why the university might want to get involved. If a certain speaker is coming to campus and it's likely to occasion a protest, you need to coordinate with security. You might have law enforcement on standby to make sure everyone stays safe. That entails a problem. Can you shift the cost of security to the student group? Now, you're all here, eating some delicious jambalaya and king cake, right? That was provided by a group with money. You have enough money for some little food trinkets for you, right? But there's generally not money to pay for security detail, which costs thousands of dollars. So often when the university says we're going to make you pay for security, that's just code word for saying you can't bring the speaker of your choice to campus. Okay? That's problematic. Okay, so that's step one. Who gets to decide? I think the best approach is a student gets to decide who comes to campus. Who's always good at that. But then what happens after an invitation is made? Can the university rescind or revoke the invitation? This is what's often called deplatforming, right? You uninvite someone. Is it uninvite or disinvite? What does Fire prefer?
Disinvitation.
You prefer disinvitation. I know there's a thinking behind this, but so disinvitation, right? This is far more problematic because at that point the speaker's already committed to coming, and it sends a message that the way to stop speech you disagree with is to complain enough to the administration that you don't want the speaker on your campus for whatever reason, whoever he or she happens to be. Okay, so the invitation goes forward, the person comes to campus. At this point, I think students can do a lot
short of disruption. And I mean that sincerely. First off, you can dissuade your friends saying, don't go to this event. Use your own speech to counter that. You know what, this person is a racist or a bigot or whatever words you want to use, and tell your friends, don't go to this event. You can protest outside the room, right? It's actually fairly intimidating. I'm not saying this for sympathy, but for a speaker to walk through an entire throng of people telling, here's what you're doing that's wrong, that gets to you, right? This is not like someone tweeting at you anonymously. This is a face-to-face interaction that you can convey your message to the speaker. You can protest inside the room. I think there are even ways of protesting inside the room that are respectful, right? For example, you can sit in the back and stand up, hold up signs, right? It's every right of students to make it as uncomfortable as possible for a speaker they disagree with. Use your own speech. After the event, if there's a Q&A, ask them some tough questions, right? Don't let them get up easy. You pin them down. If there's a microphone, you be the first one up to that microphone. And I think there might even be, and I say this with the slightest trepidation, during the speech, occasions where an outburst may be warranted. I don't know exactly where that is, but if the person says something so inflammatory, say, oh, come on, right? Throw us off his game a little bit, but I think if it's in a limited way, that might be permissible. Okay? But where does the line get crossed?
I think the line gets crossed when you go from protesting to disruption. And this is an important distinction which I want to draw. It's a basic fact of human communication. Only one person can talk at a time, right? I'm talking, you're not. If we're both talking, that's an argument, that's not a communication. If any of you are in class, right, and your professor's giving a lecture and you start talking over them, Professor Medina, are they in trouble? They're in trouble, I think so, yeah. I would not recommend it in her classroom. But there's a good reason, right? We have a discussion, I talk, you talk, I talk, you talk. But the shouting down disruption is designed to frustrate me. And that does three things. I can't convey the message I was invited to give. The students who invited me can't hear what they want to hear. And other students who just wandered in for some king cake, they also can't hear the message. So when you shout someone down, you're not only helping yourself, you're harming others who may have wanted to hear that message. This raises a tough question, right? My event was roughly an hour long. They shouted at me for about 8 or 9 minutes of that 1 hour. Was my event disrupted? The university, CUNY, said, no, Professor Blackman had almost 15 minutes to talk. He was fine. What are you complaining about? I'm actually conflicted. I don't know the answer. I go back and forth on my own, even though I was the guy there. I think it's a good, tough question. But in large part, the reason why they only protested for 8 minutes was because I didn't flip out and run away. Right? I could have said, screw this, I'm leaving. Or I could have said, you guys are a bunch of little snowflakes. I'm going to start yelling at you and calling you all these names. But I didn't do that. I tried to engage them. And because I engaged them, they realized they weren't getting through to me and they left. So I think trying to say only 8 minutes of an hour is a very difficult question. Okay, so now comes a harder one, right? Discipline. If any of you went to Professor Medina's class and you stood up in the front of the room, stood right behind her shoulder and said, you know what, you are a bad teacher, I hate you, whatever, you're probably getting arrested, right?
I hope not.
If they were standing inches over your shoulder, would you?
Oh, on top of my...
They were standing right behind me, inches behind me.
I think I would try to first engage before calling for security and try to
You are generous.
create some professional distance and engage civilly first and try to exhaust those peaceful alternatives before.
Would you say there's some colleagues that may not react the same way?
Probably.
Okay,
yeah.
thank you. What they did to me, I'll give you an example. If Ruth Bader Ginsburg was giving a lecture and the protester was standing 6 inches behind her shoulders, think they'd be arrested? Yeah, okay, easier example, right? She's back on the court today, she's okay, guys, don't worry. I think the close proximity is problematic because there's a risk of violence and situations can turn ugly quickly. I didn't react, but they were standing as close as this board is to me, they were standing right behind me. And when you're looking forward, you can't tell what's going on your left and your right, which is actually somewhat, intimidating. It is, right? There were about a dozen of them. There was one of me. One security person in the back of the room. He couldn't have done a damn thing. So I think the close proximity, right? The university should try to remove people from the room, but then that's exactly what they want. They want you to drag them out. So which creates a problem where basically it's like, okay, I'm going to stand here no matter what. So if they won't leave the room, what happens after the fact? Can you impose discipline, right? And there are different ways the university can discipline students, right? From, you can bar them from extracurricular activities, put a letter in their transcript, send a letter to the state bar for character and fitness. There are different ways of university disciplining you, short of expulsion and short of arrest, perhaps. I think schools should tread lightly here, and I mean this sincerely. Students should have an avenue to express their discontent with the speaker on campus. But the disruption might rise to a level where discipline is warranted. Why? If one speaker is disrupted and there are no repercussions, then the next speaker will be disrupted even more so because students will know it's an empty threat. And at that point, the students have now exercised control over the types of speakers that can come on campus. And again, I don't think you need to send a letter to the bar, but at least some mild sanction. You can't do an extracurricular for a semester. Something far lesser may be warranted if it's a disruption that has a risk of physical violence. Now, if there's physical violence, if they beat the speaker up, yeah, then I think we can all agree you got to engage. But the line between someone standing 6 inches from my shoulder calling me names and violence is pretty thin. And it could have turned ugly, I think, quickly. It didn't, thankfully. And I didn't feel threatened, to be perfectly honest. I didn't feel threatened, but it could have. Right? So where does this leave all of you, right? We shouldn't get to the point where students feel the only way to convey their message is by protesting the speaker. Events like this are important because they discuss the values of free speech in advance. And you can think now, how are you going to react to these sorts of events, not by shouting someone down, but by using more peaceful and, I think, more effective methods. The shouting down is not effective. Honestly, it makes me look pretty good. It makes the student look pretty bad. The video's on YouTube. You can watch it. Just Google Josh Blackman CUNY. It's got like 30,000 views. Students don't come out looking too good. They don't. But there are more effective ways of sharing your message. I think I'm just about out of time, so I'll sit down and, you want to do questions now or at later? What do you want to do?
We'll do them at the end if you don't mind.
Is that, but you get the first question at the end, okay? Okay. Promise. Okay. All right. Thank you all so much. There's a mic over there if you want to just clip it to your...
Oh, sure.
Good afternoon, everybody. My name is Bryn Madway. I'm an attorney at the Foundation for Individual Rights in Education. We are a nonprofit based in Philadelphia, and we help students and faculty members when they run into trouble with their First Amendment rights on college campuses. We're very proudly nonpartisan and non-political, and I say that because I think it's important to know from the beginning where I'm coming from. Which is a place where we will help students and faculty members regardless of what they say when they come to our door and submit a case online. And I say that too because I think it's important that everyone in this room know that if they are silenced on campus, if they run into an issue, they should submit a case on our website and ask us to help them so we can take a look at it. I think today's topic, the prompt, was and is a very interesting and meaningful prompt, which is, what are the obligations of a university when academic freedom is threatened because of concerns related to sort of the content or the viewpoint of the speech? And I wanted to take and I'll keep my remarks relatively limited because I think that the best way to engage with this topic is through discourse and dialogue. I'm a big believer in the Socratic method and a big believer in asking questions. I think, though, that I wanted to come to today's prompt from the back of it by first talking about what is hate speech, because I think it's something we see in the media a lot. And I think that the First Amendment gives us an answer, which is that hate speech is protected under the First Amendment. The First Amendment doesn't impose, there are not many categories of speech that are banned under the First Amendment, and we see that through case law time and again. So for those who haven't taken a First Amendment class or constitutional law yet, what we see is that under the Constitution, only things like obscenity, true threats, fighting words, incitement, slander, and harassment are things that a university could a public university could ban on campus. Hate speech isn't listed there, I think, for a couple of reasons. First, I think it's very difficult to define what hate speech is and what it isn't, and any regulation of speech, we need to make sure is limited as narrowly as possible. I think case law backs this point up. We've seen the court, the Supreme Court of the United States, uphold a lot of speech that's offensive, even in the past couple of decades. So I think if we look at cases like Mattel v. Tam, which was a patent case from just a couple of years ago, we see the Supreme Court saying that even though something's offensive, it's entitled to First Amendment protection. We see that too in cases like Snyder v. Phelps, where offensive protests were granted First Amendment protection because the court said that they were constitutionally protected. And I think on campus, it's important to recognize this too. One of my favorite cases is a district court case out of the Northern District of California. It's the College Republicans v. Reed. I encourage you all to take a look at this case. Quick way to find it is on FIRE's website. We have a First Amendment library with all of these cases up and available to the public. And what the court says there in the context of a civility code is that speech may be inflammatory, it may be offensive, and that often happens when we're talking about the issues that we are most passionate about, and then it strikes down the civility code at a college. And that's something that I deal with almost every day of my life. I'm a practicing First Amendment litigator at FIRE, and so we take, so we take cases where students are accused of harassment or accused of violating a civility code based on their speech. Where I think this then ties into speakers and universities too, importantly, is in the context of academic freedom, where a professor may pursue a line of research that others don't like, may give a controversial speech on campus or off campus. And again, I think there the university has obligations once they've hired a professor to ensure that their First Amendment rights are upheld. And we see that in so many different cases. I think the Third Circuit has said that academic freedom is the lifeblood of a public university. And I don't think that within the context of First Amendment law that these are controversial or unsettled points. Professors have a right to academic freedom. FIRE has a case going on right now in the United States Court of Appeals for the Fifth Circuit about a professor's right to teach based on her own teaching method. And I think that what's important is the need to engage in dialogue and to look at academic freedom is something that is beneficial to everybody. And again, it's a constitutional right. So I'll cut my remarks off very early, so to save as much time for questions, as this room is very full, and I'm sure that many of you have questions for us.
So, is it okay if I speak from right here? Greg, because I'm going to diverge from my planned remarks a bit. I don't want to run over, so would you keep me and let me know? So first of all, I am delighted and honored to be appearing on this Federalist Society panel with two really distinguished speakers, someone who is actually litigating, these cutting-edge issues, and Josh Blackman, who is not just apparently known on the Federalist Society circuit, but he was actually a highly respected constitutional law scholar, independent of the Federalist Society, and I just wanted to acknowledge that. And thanks to the Federalist Society for sponsoring this talk on what is a really, really complicated and very divisive and very topical issue today. And I've decided to temper my remarks a little bit because I think I almost heard Professor Blackman advocating for some interference or intervention in speech, right? Which is a problem for us and the First Amendment. And so I do have some prepared remarks. This is not an issue that I often write about. I've taught First Amendment. It was one of the first areas that I engaged with in practice, but I thought it would be helpful to sort of think about it from the perspective of other thinkers who've given a great deal of thought. Jeremy Waldron, who is a highly regarded professor of law and philosopher at NYU, in a series of lectures published by the Harvard Law Review back in the 2010, culminated in a book called The Harm in Hate Speech, described and defended laws prohibiting group defamation or hate speech. So much of liberal some of liberal writing in the recent decade has been devoted to justifying or making the case for regulation of hate speech. And the reason why that's been tough for liberal thinkers is because liberal thinkers traditionally have defended the absolutist view of the First Amendment, right? That there was arguably no higher value than protection of speech. And the idea that conversation had to be robust, no idea, right, was too awful to articulate or engage in. Waldron, however, contended that it was almost impossible at that time to make that case in the United States, the case for the constitutional acceptability of hate speech laws. Erwin Chemerinsky, who I know my former students know because it's his casebook that I use, in a spring 2018 article published in the Howard Law Journal, made the same point. And I'm going to quote a little bit from him. The core of freedom of speech is that all ideas and views can be expressed. The Supreme Court repeatedly has made clear that the government never can prevent, punish, or deny benefits based on its viewpoint, even if the speech is deeply offensive. As many have observed, we don't need freedom of speech to protect the messages we like. We would let those happen anyway. Dean Chemerinsky recognized that disputes over free speech on campus have a long history, even tradition. He noted in this article, however, something different about today's conversations, and perhaps this speaks more closely to Professor Blackman's experience. In the past, it was usually students complaining about heavy-handed administrations. Today, it tends to be students complaining about speakers or ideas deemed hateful and asking administrations to protect them from the ideas, right? To, in essence, disinvite, deplatform. You're describing a whole other level of activity, right? Notwithstanding the changes in the conversation, still, current First Amendment doctrine, as I think Bryn made clear, has featured robust protection for some speakers and some speech. I don't think Professor Chemerinsky is completely correct, right? Not all speech gets great protection in the United States. Universities, public and private, and law school campuses are great places in which to engage ideas about free speech. The extent to which current free speech doctrine is responsive to the needs of speakers and listeners, and the degree to which it is wanting and underserves populations that may not find it easy to engage in robust, sometimes extremely aggressive and offensive, in fact, bullying type communication. And it strikes me that at least one of the key roles, objectives, we law professors and members of the academy must serve is to empower our students to develop the communication and analytical tools to communicate and respond effectively to all speech, all ideas. And perhaps to realize when further engagement with particular speakers is unfruitful, may lack value, and to look for alternatives to engagement with the speech. I'd like to, in my remaining time, briefly address 3 ideas. I want to talk a little bit about defining hate speech. I think one of the prompts addressed that. I'd also like to give voice to some of those defenses that have spoken powerfully to supporting regulation of hate speech. Finally, a possible and proper role for universities and law school campuses to engage with free speech. And if time allows, I'll share with you what I shared with Professor Blackman, my own sort of personal story about this kind of issue. And with regards to the first, I think defining hate speech is a problem, right? It's complicated. But it's complicated in the same way that we're used to dealing with complexities in the context of First Amendment. We have conversations as to what constitutes obscenity, opinion, political speech, the extent to which conduct that is symbolic is speech, conduct that is expressive in nature is speech. We have debates about what constitutes speech, and hate speech is no different. For our purposes today, I would define hate speech, and this is a borrowed definition, not my own original conception, speech targeted to harm outsider groups. Hate speech is expression that materially and substantively harms, threatens, insults, or degrades its targets because of their membership in a group defined by a disfavored trait. Color, race, religion, national, ethnic origin, disability, gender, gender identity, sexual orientation. This is not necessarily an exclusive listing. With regards to the second idea, giving voice, articulating those voices that have argued aggressively for changing our First Amendment law, our First Amendment understanding. I want to first recommend to you some of those liberal writers, like Jeremy Waldron, like the writings of Richard Delgado, Mari Matsuda, and Charles Lawrence, for a kind of attempt to do a classic liberal rethinking. But for my few minutes here, I thought it would be helpful to describe a feminist defense of hate speech / gender harassment / speech regulation, or attack on the status quo, as voiced by Catherine McKinnon in her short book, Only Words, published in 1993. Right, this issue has been with us for a long time. And and then describe my own experience. McKinnon, a law professor largely responsible for the legal recognition of sexual harassment as an actionable form of sexual discrimination under Title VII, explained her rethinking of traditional First Amendment values to allow for regulation and prohibition of speech, literature, art, symbolic conduct, like, for example, pornography. And our focus today, speech that constitutes harassment, whether sexual or racial, rests on a large part on the fact that, for her, First Amendment principles were set down and formulated in a world that accepted, featured racial and sexual inferiority. Indeed, she makes the case that it's the equivalent of sexual torture, rape, as part of the acceptable status quo, and that thus those first principles have to be reformulated in a world where racial and gender equity now are the norm. No longer ideas or values that are denigrated or ridiculed. I'd like to read you, if I have time, to read just a short from her book. It's a paragraph that she's really writing about the debate, but she's kind of giving it in her own kind of literary, creative writing way to kind of convey what the effect is on the listener, or the speech that is shut out. She says, in the wrong page, you learn that language does not belong to you, that you cannot use it to say what you know, that knowledge is not what you learn from your life, that information is not made out of your experience. You learn that thinking about what happened to you does not count as thinking, but doing it apparently does. You learn that your reality subsists somewhere beneath the socially real, totally exposed but invisible, screaming yet inaudible, thought about incessantly yet unthinkable, expression yet inexpressible, beyond words. You learn that speech is not what you say, but what your abusers do to you. Your relation to speech is like shouting at a movie. Somebody stop that man, you scream. The audience acts as though nothing has been said, keeps watching fixedly, or turns slightly, embarrassed for you. The action on screen continues as if nothing has been said. As the echo of your voice dies in your ears, you begin to doubt that you said anything. Soon, your own experience is not real to you anymore, like a movie you watch but cannot stop. I think it's fair to say that there are some aspects of that description that probably fit your experience as well. So let me share with you my own personal experience. It happened very early in my career here as a professor at Loyola. It was in the context of a speaker that I invited on campus. It was a speaker that I invited on campus because she was a nationally prominent woman. And we did not have that many nationally prominent women. And so I invited her to campus and thought we were going to have a talk and everything was going to be wonderful. And before I knew it, there were, we had people protesting, we had death threats, and the weekend before the talk, I agonized in fear that the president of the institution, who had himself been threatened with being killed, was going to call me and ask me to rescind the invitation, right? I was not tenured. And I could not help think that if he did ask me to do that, I would have to say no or offer my resignation, and there would be the end of my life as a law professor. And I cannot tell you what a relief it was. Not when I first got the call, because when I first got the call, I thought, oh gosh, what am I going to do? And I knew what I had to do. And fortunately, that's not what, the call was not to ask me to take the invitation back. The call was to tell me he was 100% behind me, and that he was sorry that things had developed the way that they had. And when that speaker came to town, we rode around with a police escort, and the president had a police escort, and nothing terrible happened. But I can tell you it was a pretty very nerve-wracking experience. But I've never forgotten that all of the push was coming from outside the community. It was not the law school community, it was not the university community. What a wonderful feeling it was to get that support for the tenets of academic freedom, and the importance of welcoming that speech, even if it posed speech that was tremendously challenging for a Catholic Jesuit law school and institution. The speaker was Kim Gandy, who at the time was the leader of NOW, the National Organization for Women, and the threats were coming from very pro-life, anti-abortion groups that felt this was the time when there were a lot of violent, there was engagement with violence, and so it was tough for the schools to withstand that much community activity. And it was tough for me, but it was once again, we had that speaker, we welcomed her, we had a full house, and I'm not sure we would have had a full house, standing room only, if it hadn't been for all of the publicity that we got as a result of that dreadful. In closing, I'll harken back to Dean Chemerinsky's closing in his article, and I encourage you to look it up, and he actually talks about a number of incidents where speakers have been protested, students have petitioned the school to ban the speaker, et cetera, Speakers and purveyors of ideas, even hateful ideas, may have the right to speak, but campus authorities, including deans, professors, and students, have the right to speak back. I would say after the speaker has had his turn, right? So my response is still premised on civil speech, right? You hear what the speaker has to say, and then you respond. Challenge. We can challenge the ideas. We can denounce the ideas, right? Campus authorities, including deans, professors, and students, don't have to stand by silently tolerating the speech after the speech is done, right? If you invite the speech, you have the speech, giving the appearance of approval and agreement. With that, I'll rest and see what you guys think. Any questions? I think you had promised.
We had a question.
Yeah, question number one.
I didn't understand the context of why you were being protested. That was the main thing, because I was a little lost.
Oh, sure. I am a right of center law professor, which is something of a minority. There are not many of us. The specific grievances they had were some of the things I've written during the Trump administration. For example, I've argued that the travel ban was lawful. I think it's a bad policy, but it was legal. I argued that I think the DACA policy was unlawful, but it was a good policy. And they viewed my policies as evidence of me being a racist, a bigot, a homophobe, a misogynist, the entire list. And they actually handed out the pamphlets throughout the school, taking things I've written, very much have context, criticizing. So actually, I applaud the students. I think they worked really hard to object to my presence, and I'll give them credit for everything up to the disruption. Everything else, I think, was well within their prerogative to do. But the disruption during the speech is where I would draw the line. Thank you for the question.
Go ahead.
In regards to the hate speech suggestion you made, Professor Dino, I wonder what's more dangerous, a bad idea that's allowed to fester, that's allowed to grow in a small community that's never expressed and never defeated, that might hurt somebody if expressed, or an idea that is expressed, a bad idea that is expressed, does hurt somebody, but is defeated in public discourse. I wonder which one of those is more dangerous when we talk about this hate speech, defining what's hate speech. The plot will go away. It will stay a secluded sector of society that it will never be challenged. I don't think defining it as hate speech necessarily will fix the issue.
So one of the things so here's the thing. The reason why very few people who have thought about this want to regulate speech or conceive of regulation of speech as a positive value, positive good, is because of course then you have to decide what speech is it that you're going to protect and what aren't you. We've already drawn some of those lines. There's some things arguably are not, some things are not protected, right? Even if they're speech. I think because we come from that tradition, think back to the time of the framing where in England it was absolutely not okay to argue or advocate ideas that opposed your government, right? So the idea is you open up the door to regulation, and then its viewpoint, its viewpoint, who then decides, and inevitably, every despot, every tyrant, every totalitarian form of government, one of the first things they go after is speech, free speech, right? And I thought about, in preparing for this talk, one of the slides I was going to have is a slide that to me communicates what hate speech is all about. And it would have been one of the photographs of people demonstrating at the time of desegregation, when, for example, our alumni, Judge Skelly Wright, was hung in effigy, and he received tons of hate mail, and there are volumes of it in the Library of Congress. He kept every single one of those letters, and it's just hatred spewing out, right? And the experience that the child, right, who was Norman, the painter, yes, captured so potently, right? That to me is hate speech. It went beyond hate speech because you have physical conduct that was accompanied with the speech. But that to me is a classic example of hate speech, right? And I don't know that, how do you draw the distinction between speech like that injures, poses a real threat or injures, which is basically what you need under the First Amendment, to speech that is, different, that's just communicating an idea. I think it's tough. I think the other lesson we can turn to in terms of speech that bullies is the, I hate to hark back to Germany, not during the Holocaust, but Germany in the pre-Holocaust years, when Hitler's demonstration, Hitler's speech became about really stomping down any other alternative viewpoint. And so one of the first things he does is, after he's bullied everybody out of existence, is to make it law, right? So I think that's why liberal theorists have a hard time getting on board the let's regulate hate speech or any kind of speech with a vengeance, because we are very, very conscious that, that line is going to be drawn by whatever dominant group is in power, and how to provide principles that are, have some adherence to the rule of law and that don't just reflect whatever political maturity.
If you don't mind,
Absolutely.
I was going to add two things, and I think the first is what you just hit on, which is, I think, one of the dangers really with adding new categories of unprotected speech, especially loosely defined ones, is exactly the idea of majoritarian control over speech and discourse. So we may, if we enact a ban on anything really because it's popular now, I think the question is what happens when it becomes a ban on something that we like instead of things we don't like. And I think the other thing, the quote that I'm always reminded of is sunlight is the best disinfectant. And so I think when we drag unpopular views out into discourse, we can defeat them with our own First Amendment rights, and we can speak about the things we don't like. And so I think confronting those opposing views, confronting the views we don't like, even the ones we find the most vile, is more effective than sort of confining them and not letting them come out. I think discourse is the best remedy.
I have a question for both of the guest speakers. So it seems like you guys have a passion / have made like a career out of, defending hate speech. So my question is, like, usually when you support something like that or whatever, it's either like, have you guys experienced hate speech before, or have you maybe spewed hate speech? And then also, do you ever have like a moral dilemma, like from the things you write or the things you say? how those can hurt other people. Does it ever like affect your work because you made a career out of this?
I'll start. I defend a lot of speech that I don't like. There are things that I would never say, views I would never hold, but I would still defend the right of others to say them. And the reason why is that censorship has a bad habit of creeping, where you start censoring speech at the fringe that is pretty awful. And if we accept that form of censorship, it very quickly censors to things that I don't find so fringe. So do I defend things I disagree with? I do. Do I think about how things I say affect people? All the time. I'm a professor at a school. I have students from all walks of life. And I often think about how things I write affect them. One of the benefits of having tenure, which Professor Medina alluded to, is you have a little more autonomy to take positions that some people, students otherwise might find offensive. And I'm cognizant of that. But I believe in certain causes. Free speech is one of them, and I'm happy to advocate for it. Thank you for the question.
I defend the right of people to speak, and so I defend a lot of speech every day that I may personally disagree with, but I think censorship does encroach, and I think that if we don't defend all speech, then we will lose our own right to say what we want to say. And so I defend the speech of people on the right, I defend the speech of people on the left. I think of where I was about a year ago, which was defending the First Amendment rights of a student who was detained for distributing she was a socialist, and she was distributing anti-capitalist literature on campus, and she was actually detained for about 15 or 30 minutes for distributing these materials on campus because they were afraid that the anti-socialist or the pro-socialist materials would disrupt the campus. I think very hard about the words that I say, and about the consequences of them. But I think that the First Amendment protects all of our speech, and I don't think that allowing for censorship will do us any service. I think the First Amendment protects what it protects, and we have to confront the views that we disagree with, regardless of how offensive we may personally find them.
Sorry, one of the questions is also, have you guys ever been a victim of hate speech? Or, I don't know if you'd call it a victim, but has hate speech ever been directed at you?
It has. It has. As an openly LGBT person, I've absolutely experienced it, and I've had to defend folks who would restrict my own rights. And it's difficult to do. I think that as both a First Amendment advocate and as an attorney, I think we all face the fact that we may have to do that one day, and it's difficult to do. But as attorneys, we have to put forth and defend the views of not put forth, but we have to defend our clients, and we have to defend our clients' rights, even when that may restrict our own.
Yeah, so I have a question. I was formerly a teacher of small children, and I guess my concern with this, I'm all for free speech, but I guess my concern is where free speech starts to cross, like that, especially hate speech, when it becomes like harassment and bullying, and where it's all becoming to have a negative impact on the emotional well-being of a person, especially if they're part of a very particular marginalized group. LGBTQ could be one, but also I'm talking about undocumented children. And so when these undocumented children at school are exposed to hate speech from their professors, their teachers, that has a negative impact on children, for example. And so where do we draw the line of teachers' rights to freedom of speech, and even hate speech? Because I would consider that hate speech, especially if they're talking about children in a negative way, their own students, in derogatory terms. I'm not talking about fancy words. I mean, words were said that were pretty sad. But I guess, how have y'all addressed that in y'all's practice when y'all have y'all faced that scenario where it involves students, teachers in contexts such as these?
Teachers in primary and secondary school have very limited First Amendment rights.
wow.
Almost none.
Yes, I'm gonna
Very
say,
little.
yes, they're gonna lose those cases.
Well, they said curse words about these children, which was very, and it was tied to their, one of the protected characteristics, their race, but also to their, more than just race, but they're also their, legal status in the country. And so I had some children who were depressed and were, had suicidal notes. It was a very sad experience for me. So I just wanted to put it out there. It's serious consequences. So, thank you.
How would you characterize speech that's targeted to harass and injure an individual? It's strictly individualized and not motivated by group identity. Should that be governed by the same rules that would govern hate speech that's classically group motivated?
Well, I mean, to be clear, a couple of the questions have used the word hate speech. I don't think we have a definition of what that is. I actually debated Jeremy Waldron at NYU a couple months ago on this exact topic.
Fun.
And, you know, whenever you put him to the question, what exactly is hate speech, he sort of hems and haws a bit, and he does a little dance. And he's a very bright scholar, very gifted speaker. But if the definition of hate speech is speech that you find offensive or speech that might make you feel less as a person, that's pretty squarely within our First Amendment protection. The Supreme Court said over and over again that offensive speech is protected. And the mere fact that you make that offense based on some protected characteristic doesn't remove it from those protections. We have cases like R.A.B. versus St. Paul. This is an awful case involving a cross burning. We had these teenagers who burned a cross in the yard of an African-American family. They weren't prosecuted for trespass, they weren't prosecuted for arson, they were prosecuted for cross burning. And unanimously, the Supreme Court found the prosecution was unconstitutional. Now, another case, Virginia against Black, which concerns a cross-burning filed with a threat. Threats are not protected speech. So the type of speech prohibited is speech combined with something else, right? But the mere speech itself, at least in the current doctrine in the United States, is squarely protected. In the academic context, the concept often comes up is a harassment, right? A hostile learning environment or a hostile education environment. This is Fire's bread and butter, right? These are some concepts that universities have wrangled to permit punishment for speech. You say, this professor is engaging in a hostile learning environment. Or in the employment context, this public employee is engaging in a hostile work environment. And through these doctrines, courts have sort of sidestepped the First Amendment implications. I have questions about those doctrines. But there is no category of hate speech in our jurisprudence in the First Amendment today.
What I would add is, in the context of harassment, the case Fire cites is Davis v. Monroe, and in that case, within the context of peer-on-peer harassment, there are standards through which a university could restrict harassment, and so there the definition is something that's so severe, so pervasive, so unreasonably, so that a reasonable person would find offensive, that it actually restricts an educational opportunity.
And this actually goes back to Catherine McKinnon's work on sexual harassment law, which was recognized by the court as actionable under Title VII of the Civil Rights Act of 1964, in Meritor versus Vincent in 86, 87, something like that. And since that time, we've had numerous cases from the Supreme Court in the context of Title VII, continuing to recognize as actionable hostile environment cases, and yes, they've been transplanted to now this a broader context. And so, and there's a vigorous debate about the extent to which harassment can constitute words alone, speech alone, or the degree to which it requires something more. and many scholars, including myself, have argued that courts have just completely ignored the reality of the receiving end of the hostile environment in requiring or, expecting a really high level of hatred or hostility targeting the person before it will become actionable. It's really a tough area.
But I heard, am I interrupting you?
No.
Early on in the discussion, there was, I thought I heard an attempt to equate hate speech with group defamation. There are other terms that were used that were stronger, threats, insults, that sort of thing.
So Jeremy Waldron did a piece where he,
Well, I kind of want to know what you all think, but is that a helpful, point of beginning? Do we agree that group defamation, whatever else hate speech is group defamation something that the state may prohibit? First of all,
no,
one thing we
I
haven't
did
done
not.
adequately is I don't think we're talking about the public sphere on one hand, the soapbox at the corner, public debate, newspapers and so on. And then we're talking about the university environment, the college environment, where I think different standards also apply. Obviously, incitement to violence in the public sphere and incitement to violence within this room should be subject to regulation. But certainly, there's a range of speech that would be permitted in the public sphere that ought not, perhaps not, should not be permitted in a university, public or private. So I thought maybe one way to get at that problem, we haven't really spoken, I haven't heard anyone speak about it today, would be to talk about some category of activity that Isabel would agree is hate speech, but that I would agree is group defamation. For example, anti-Semitic remarks in Nazi Germany, for example.
So I want to make it very clear. I'm not suggesting that I think group defamation is the equivalent of hate speech. I was really just referencing a Waldron article where he links the two.
Well,
together.
hate speech would be the more general category. Group defamation would be much more specific, much more, much narrower.
I'd have to go back to Waldron's article and focus on that and give it a lot more thought than to make any kind of helpful commentary. Josh, do you want to take that on?
I haven't given it
It's
much
been a long time since
Sorry.
I've looked at Beauharnais, the group defamation case.
Yes.
So
Bryn,
I'm not sure I understand your question.
Well, it used to be defamatory to call someone a communist in the 1950s. No longer is it, right?
Now might get you elected president. Next question. Yes, ma'am.
So I have a question for you, Professor Blackman. I know you referenced something about arrests up here and should we be involving the police? What is your threshold to that? What would be your proposed threshold? Because I know police have a lot of discretion and we already have a epidemic essentially going on right now. And don't you feel as though involving the police in free speech would lead to an even greater epidemic and maybe even a bigger sense of inequality? Because I know for the all boys school, I don't know where that was, with the Native American.
Covington, Kentucky.
Yeah, I know that could have led to a lot of arrests of young boys, So what would you say that the threshold should be?
It's a hard question. Again, I try to look at this as objectively because, look, I'm 6 feet tall.
Right.
I can't handle a dozen people. If for whatever reason that turned violent, I would have probably gotten injured. I would not have favored a police presence because I don't think that crowd was hostile. I'm with you on that.
Yeah.
The question is, what happens if it suddenly becomes hostile? Because when you have 12 people who are standing around and they're very angry, and they decide to, get in my face, because it's in DC, and they start shouting at me.
do dumb things.
Right.
What I don't know is, and I think you raise a fair point, if there's police in the room, it might chill speech in other ways to inhibit a discussion that might be important. So I don't think in my incident there were justification for police. I don't think it was there. Unfortunately, I think my answer is the speaker has to tough it out, and if it turns hostile quickly, that might be part of the cost of doing business. I've actually discussed this with related liability insurance for public speakers. We looked into this at Fire.
Oh, I think once or twice, but nothing.
I've mentioned this at federal side that if the speaker is actually attacked, you have insurance for everything. You guys are lawyers, right? Is there actually a cause of action? Is the university of premise liability? The speakers engaged in torts? I mean, this is not a trivial question if you can think of your 1L tort class. But I think your question's good. I would try to keep police away. There was a plainclothes cop in the back. No one knew who he was, which was fine. That might be one way of handling it. There were plainclothes people, but he was one guy in the back, and I was 12 people up front. But I mean, just in your own world, imagine if you give a speech somewhere, and people will start surrounding you, and they're inches away, and just ask yourself: would you go out and do that speech? Would you run away? Would you?
I mean, yeah, and I completely appreciate your response, and I respect your opinion, but I think whenever you have opinions and beliefs, or you just defend something that a group of society doesn't necessarily agree with, I think you kind of take on those risks sometimes. And if we didn't have the civil rights movement and people doing that years ago, I mean, where would we be today?
Yeah, I'm not asking for sympathy. I mean, like, if look, no one broke my skull, right? No one put a fire hose on me, right? This is pretty small potatoes that happened. So I'm not asking for sympathy. And I do think at some point you have speakers who have broken bones. We've had this. And what is the university's role in, number one, keeping the students safe, but number two, also allowing protests to proceed? And there was an incident in Houston, not so far from where I live, where there was a speaker who went to Texas Southern, which is HBCU in Houston, Thurgood Marshall School. And this guy was very conservative. And they said, we need to remove you from the room, we fear for public safety. And he's like, I'm not leaving. He didn't think there was a threat, but the school wanted him out of there. He said, we're going to take you out. So when the police go to the speaker, come with me, and he's like, I'm not leaving. They basically have to drag him out of the room, which is almost the opposite problem. So, again, I'm conflicted. I'm almost better off not having a security force, but with the recognition that it may lead to, well, my dad was scared of my dad's like, you are never doing this ever again. You're never going back there. He was so scared. He watched me. He was almost crying when he saw this. Like, I thought they were going to kill you. Right? I'm like, yeah, it's fine. Don't worry about it. But a lot of it also is based on the speaker, him or herself, who can decide how to handle it. Yeah.
So this situation, I just want to see what you think about this. So you have the chance to not talk. You don't have to say the stuff that you're saying. You don't have to go to these schools, right? And people don't have to protest what you're saying. But somebody, like, let's say me, walking down the street, I don't have the chance to not be black. And somebody to say the N-word to me, right? And then that's what you're defending that. But I can't not be black, and they can still say hate speech towards me. But people are protesting for the things that you're saying, and you could stop saying them, and that hate speech, if that's what you want to call it, that they were doing to you is gone. So what is your opinion on that?
Well, again, I don't think what they're saying was hate speech. I think they were exercising their rights very well. And I think the views they had are legitimate views, and they're allowed to have it. I think your question is more to why do I do what I do? I think that's more of your question. Why would I go there and give a speech? Is that what you're...
No, that was like the main part of your discussion, and you seemed very bothered by like the fact that a bunch of people were protesting and the different things that they were saying towards you, and that was you just being a speaker on a campus. But if you're a student on a campus, right, and somebody's saying stuff to you when you're just trying to live your regular life, and like you can be bothered, but are you just saying for those people who receive that they should just take it and just like you took it when they were talking to you?
I'm an invited speaker, and that's a fairly unique thing, right? They invited me here. They gave me the front of the classroom for however much time I have. What I'm talking about is that specific context. There are many other contexts where students don't have that opportunity to respond.
respond. They don't have this sort of undivided attention. And I'm sympathetic to that. Look, I'm a professor of students from all walks of life, and I recognize that people have difficulties. They have struggles that I don't face. I get that. I understand that implicitly, which is why I'm not asking for your sympathy. My focus is more narrowly on what role does the university have to allow speakers to prevent this sort of disruption so people can be exposed to it. Let me just finish with the story. I know we're short on time. When I was up there protesting, or looking at protest, it was actually an African-American student in the back, right? And he was there to actually watch me speak. And the protesters were actually shouting, like, why are you here to see this racism? And they were actually mad at him. And I was sort of just staying inside, it wasn't my business. And he said, I want to hear him speak and ask me tough questions. Let me tell you, this guy asked me questions for an hour. He was asking 20, maybe 15 or 20 questions that were really tough on criminal justice, on slavery, on abortion, on every issue you can imagine. They're all on camera, you can listen to them, right? And he asked me every question. And he said, you know what, I don't think you persuaded me a damn thing, but I'm glad you spoke. Another guy was holding a sign saying that you are an oppressor. That's his opinion. I talked to him for maybe 20 minutes after the event. And he came up to me and said something. He said by email, actually. He said, you know what, I don't think you're an oppressor because I heard what you had to say. There's a value in hearing someone speak. They might surprise you. They might give you something you haven't heard before. And if the speaker simply shut down that he can't speak, that exchange doesn't happen. Right? The value of, look, you can watch me on YouTube. That's fine. But you just asked me 2 or 3 very good questions. And you can't do that on YouTube. The value of these events is having one interaction, which is why the university should allow the speaker to go on. If you guys had chatted me after the first 30 seconds, you would have heard a word I said, and I'd be at the door, right? Or you've left. That is my focus. I think it's a value worth fighting for. It's a value worth arguing for. And I hope, you know, the people in Loyola go and talk about this afterwards and tell your friends, oh, this guy was an idiot, or this guy was nice, or whatever, and then, you know, email me. I don't care. I respond to, I think, 4 or 5 emails that day from the CUNY kids. They were talking to me. But I think this is a worthwhile proposition. FIRE is a very good group. They actually, I should have disclosed earlier, I actually submitted a FOIA request to CUNY, and FIRE was my kind of lawyer on that one. Because I wanted to see what the university actually had done about this, and they didn't really do much. So there was nothing productive that came from the FOIA search, but FIRE is a very good group for these sorts of things.
And I think what's important to keep in mind, especially on public campuses, is that there's very little universities can do to restrict what is said in the open outdoor areas. Just like there's little the government can do on the street corner, but it's up to all of us to use our First Amendment rights to advocate for the causes that we believe in. And I think that if there's one takeaway is that I always try and leave students with, it's that we all have our own First Amendment rights, and we all have our own right to engage with others. And I think that we can use that dialogue to advocate for our own beliefs.
All right, I think that's time.
And if you have more questions, I got time. So
Yeah, and
afterwards.
I have plenty of time.
Hey, thank you all so much for coming, and make sure to give a round of applause. If you haven't signed it, sign
so
it.
much, Bryn. That was lovely.
Please do so before you leave. Thanks again for coming.
So we start people in this room, and we have like 20 on